Grand juries in the United States are groups of citizens empowered by United States federal or state law to conduct legal proceedings, chiefly investigating potential criminal conduct and determining whether criminal charges should be brought. The grand jury originated under the law of England and spread through colonization to other jurisdictions as part of the common law. Today, however, the United States is one of only 2 jurisdictions, along with Liberia, that continues to use the grand jury to screen criminal indictments. Generally speaking, a grand jury may issue an indictment for a crime, also known as a true bill, only if it finds, based upon the evidence that has been presented to it, that there is probable cause to believe that a crime has been committed by a criminal suspect. Unlike a petty jury, which resolves a particular civil or criminal case, a grand jury serves as a group for a sustained period of time in all or many of the cases that come up in the jurisdiction, generally under the supervision of a federal U.S. attorney, a county district attorney, or a state attorney general. And here's evidence ex parte. The federal government is required to use grand juries for all felonies, though not misdemeanors, by the Fifth Amendment to the United States Constitution. While all states in the U.S. currently have provisions for grand juries, only half of the states actually employ them and 22 require their use. To varying extents, the modern trend is to use an adversarial preliminary hearing before a trial court judge, rather than grand jury, in the screening role of determining whether there is evidence establishing probable cause that a defendant committed a serious felony before that defendant is required to go to trial and risk a conviction on those charges. Some states have civil grand juries, investigating grand juries, or the equivalent, to oversee and investigate the conduct of government institutions, in addition to dealing with criminal indictments. In the early decades of the United States, grand juries played a major role in public matters. During that period, counties followed the traditional practice of requiring all decisions be made by at least 12 of the grand jurors. Any citizen could bring a matter before a grand jury directly, from a public work that needed repair, to the delinquent conduct of a public official, to a complaint of a crime, and grand juries could conduct their own investigations. In that era, most criminal prosecutions were conducted by private parties, either a law enforcement officer, a lawyer hired by a crime victim or his family, or even by laymen. A layman could bring a bill of indictment to the grand jury. If the grand jury found there was sufficient evidence for a trial, that the act was a crime under law, and that the court had jurisdiction, it would return the indictment to the complainant. The grand jury would then appoint the complaining party to exercise the authority of an attorney general, that is, one having a general power of attorney to represent the state in the case. The grand jury served to screen out incompetent or malicious prosecutions. The advent of official public prosecutors in the later decades of the 19th century largely displaced private prosecutions. The federal constitutional right to have federal criminal charges screened by a grand jury is one of just a handful of provisions of the Federal Bill of Rights that does not also apply to state and local governments. The Fifth Amendment to the United States Constitution provides that no person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger. Misdemeanors are not presented to a grand jury, and are instead charged by prosecutors. Information. In the United States Armed Forces, an Article 32 hearing is used for a similar purpose. The grand jury right may be waived, including by plea agreement. A valid waiver must be made in open court and after the defendant has been advised of the nature of the charge and of the defendant's rights. Rule 6 of the Federal Rules of Criminal Procedure governs grand juries. It requires grand juries to be composed of 16 to 23 members and that 12 members must concur in an indictment. A grand jury is instructed to return an indictment if the probable cause standard has been met. The grand jury's decision is either a true bill or no true bill. Members of a grand jury are selected at random from the population of the district or division in which the federal grand jury convenes. All citizens have an equal opportunity and obligation to serve. Grand jury proceedings are secret. No judge is present. The proceedings are led by a prosecutor, and the defendant has no right to present his case or to be informed of the proceedings at all. While